Welcome. Good morning. This is Bob, and the recording has started. So, Megan, if you want to read us in.
You got it. The Behavior Analysis Regulatory Board meeting is convening at 9:04 a.m. on July 11th, 2025. This meeting is being held in person and through MS Teams video conference and is being recorded. The recording will be posted to the internet for public viewing. I will now call roll. Megan Johns, here. Jennifer White, here. Mason Williams,
Here.
Samantha Parnham,
Here.
Marie McMahon,
Here.
Corey Stump,
Here.
and Jamie Whipple.
Here.
Members, when you wish to speak, please state your last name for the record. Board members are asked to not use the chat feature during meetings. The Health Licensing Office asks that individuals attending through MS Teams keep their phones muted and cameras off during the entire meeting or until they are given an opportunity to comment during the public and interested parties feedback period if indicated on the agenda. Public comment is limited to matters listed on the meeting agenda or topics relevant to what the board has statutory authority to regulate. Public members wishing to speak, please sign in on the roster sheet available in the room or email Josh Page at josh.page@oha.oregon.gov and provide your first and last name. Everyone is asked to use appropriate language, manners, and protocols when conducting board business.
Excellent. Thank you very much. Good morning, everybody. My name is Bob Bothwell. I'm on camera now. I'm the director at the Health Licensing Office. And the first item on the agenda is for the board to approve the agenda. So if we can get a motion to approve the agenda and then a second.
Hi.
This is McMahon. I move to approve the agenda.
And a second,
This is
please.
White. I second.
And that
Thank
was
you very
Samantha,
much.
right? Samantha?
I think we both did it at the same time, Jenny and Samantha.
Okay, Bob, do you want to call it?
Yep. Jennifer.
Okay, thank you. And we need a roll call vote, please.
Megan Johns, aye. Jennifer White,
Aye.
Mason Williams,
Aye.
Samantha Parnham,
Aye.
Marie McMahon,
Aye.
Corey Stump,
Aye.
Jamie Whipple.
Aye.
Excellent. Thank you. The next item on the agenda are some introductions. I think we do have some new folks that have joined the board first time today. If I can get Mason Williams and Jamie Whipple to turn your cameras on if you're able to.
Sorry, I'm new to Teams.
Not a problem.
There it is.
So Mason, you want to please introduce yourself? Your name's first on my list.
Good morning, Mr. Boswell. My name is Mason Williams. I am a public member of the Behavioral Analysis Regulatory Board. This will be my first time actually working with the state board ever. I am part of the Athlete Leadership Council that is with Special Olympics Oregon.
Excellent. Well, it's a pleasure, sir. Thank you for joining us. Jamie.
Hi, I'm Jamie Whipple. I'm the parent member on the board now. My son is severely autistic and he has been getting ABA from the age of 2 and now he's 14. So we have been through the gamut of ABA therapy and hopefully that will bring a good point of view to the group.
Excellent. Thank you very much. Chair, if you would please come on and introduce yourself.
Sorry. It takes always a minute to figure out where the camera button is when it moves. Hi, I'm Megan Johns. I'm a behavior analyst and I'm the chair of the board. This is my second term with the board, so I've been sitting on it for a while. I don't remember when we started, but yeah.
Thank you, Megan. Jennifer White, please.
Hi, I'm Jennifer White. I'm a behavior analyst, and this is also my second term. Nice to have you both on our board.
Thank you very much. Samantha Parnham.
Hi, everyone. I'm Samantha Parnham. I'm a BCBA. Also my second term. Megan, I think the answer is 2020. It was a very long time ago. So it's nice to see some new faces. So hi.
Excellent. Thank you. Marie McMahon. You're muted, Marie.
There we
There you
go.
go.
Hi, I'm Ree McMahon. I'm a psychologist and not very good with technology. This is my second term on the board. Nice to meet you.
And Corey Stump.
Hi there. I'm without internet connection, so I'm on my phone. Otherwise, I'd say hello with my face. But I'm a board certified behavior analyst. I've been on the board now. This is my second term. I believe I have 2 more years left in my service. And I currently teach at Oregon State University.
Thank you very much. And then I'll have some key staff introduce themselves. You've met Ann Thompson this morning, and my name is Bob Bothwell, and like I said earlier, and I'm the director here at the Health Licensing Office, and I'd like to welcome you both and then everybody for attending the board meeting today. I also have Tina. You want to come on and say hi, Tina? I know you're
Good
without
morning.
camera today.
Yeah. Good morning. My name's Tina Russell. I've been with the Health Licensing Office for 28 years. And I work in the I'm manager in the licensing section. Welcome.
Also, someone you'll have a lot of communication with is Josh Page.
Hello, I'm Josh. I'm the board specialist, so I send out any communications regarding the board meetings.
Thanks, Josh. And Chrissy Pickett, who is our executive assistant and board member recruiter.
Hi. Yeah, so I do the recruitment. I'm the one that you talk to on getting into the board. And then when your time is coming up, you'll probably hear from me again soon.
Excellent. Thank you, Chrissy. And last but not least, Trampus Shuck, our regulatory manager.
Well, good morning, everybody. My name is Trampus Shuck. I'm the regulatory manager. I've been bouncing around the office for about 16 years. I've been in policy and in regulatory and investigator and inspector. So I've been working with this board as well as an investigator before I stepped into this role. So yeah, welcome, and look forward to working with you.
Excellent. Thank you, Trampus. Okay, Chair, members of the board. The next item on the agenda is approval of the 2026 meeting dates. And those are, as I was unprepared, going to be 9 a.m. January 16th of 2026 and July 10 of 2026. So very similar to what we've had this year.
This is McMahon. I move to approve the meeting dates.
And do we have a second, please?
This is White. I second.
Thank you. And Chair, if we can get a roll call.
Yes. Megan Johns, I. Jennifer White,
Aye.
Mason Williams,
Hey,
Samantha Parnham,
Hi.
Marie McMahon,
Aye.
Corey Stump,
Aye.
and Jamie Whipple.
Hi.
Okay, thank you very much. And that passes. The next item on the agenda is the approval of the chair and vice chair. And we have Megan Johns, who is currently the chair, and Megan's term expires December 16th of 2026. And the vice chair is Jennifer White. And Jennifer's term expires February 13th of 2028. So the board someone from the board can nominate them together again, or nominate somebody else, and then we'll put it forward for a vote. And the floor is open for discussion.
Yeah, this is Ann. So if the current chair and vice chair would like to continue, they certainly may. If they would like to cede their position to someone else, that is also something that can be done. So if anyone feels strongly about it. I know, Megan, how do you feel about going around again?
I was just going to say, this is Megan. I do not have a strong feeling either way. So whatever works. I know it's not always helpful, but I'm happy to stay, or I'm happy to pass it along, given that my term is going to end next year.
But you will have the entirety of the year. So sometimes if folks' terms are going to end in like February or March, it would make sense to have a new person, because we want somebody to have the continuity of the whole year. But you're good to go if people would like to keep you there. If folks are happy with the way things are, we would need a motion to retain Megan as chair and Jennifer as vice chair, and a second and a roll call vote.
Aye.
Is that you, Mason?
This is Corey Stump. I was going to say I motion to move on as we are now.
Yes,
to keep,
that was me.
Oh, that was me. Okay, so if Corey did the motion and that's to retain, and Mason did the second, are we okay with that, Bob?
We certainly are.
Okay, have a roll call, please.
Yep. Megan Johns, aye. Jennifer White.
Aye.
Mason Williams.
Can't hear you, Mason.
Oh, sorry. Aye.
Thank you.
Samantha Parnham.
Aye.
Marie McMahon.
Aye.
Corey Stump.
Aye.
And Jamie Whipple.
Aye.
Excellent. All right. So we have chair and vice chair, and they remain the same as Chair Megan Johns, the vice chair Jennifer White. All right. Next item on the list, chair and members of the board, if you're ready to move on, are the director's reports. But first, we have the board membership. We've kind of covered it. Chrissy, are you able to jump on here and provide this report?
Yeah.
Or I can. You tell me if you've got it. If not, I'll do it.
I just have to pull it up, so I would just need a couple seconds. So let me pull up the report.
Chrissy, do you want me to jump in there for you?
Just got it pulled up.
Oh,
So
okay.
the director's
Okay.
report. So we are looking at the membership here. And we have we already met the new members. Sorry, I'm just trying to scroll down to the page. Okay,
13.
so we have Megan Johns. She's on her second term. She expires December 16th of 2026, and she cannot reappoint. We have Mason Williams, who is just in his first term. His first term expires in October 31st of 2028, and he is eligible for reappointment. Same thing for Jamie Whipple. Welcome to the board. We have Marie McCone, second term. She expires on 10/31/27. She cannot reappoint. We do have Corey Stump, who is also in the second term, same expiration, and also cannot reappoint. So 2027 is going to be fun. Second term for Samantha Parnham, October 31st, 2027, and she can also not reappoint. We have Jennifer White for second term. She ends in February of 13th, 2028. She can also not reappoint. We do have 2 open spots, one for a pediatrician, and we do have one for a psychiatrist. We may be in the works for a pediatrician, but undetermined yet. But we are still looking for a psychiatrist. So if anyone has a psychiatrist that's well versed in this world, feel free to send them my way, and we would love to chat with them and see if we can get them on the board. And then also we have the board member training. Some of them are required annually. Some of them are required. The overview boards and commissions is required once per term. So keep an eye out for those trainings in your workday. And if you have any questions on how to get those done, you can reach out to me. And my email's on that sheet, chrissy.pickett@oha.oregon.gov.
Excellent. Thank you very much, Chrissy.
Mhm.
Sorry to put you on the spot. So, Chair and members of the board, if anybody's following along on slide 17, we have some license issued statistics. So in Q4 of 2025, which we just are about to finish at the end of we just finished it and just heading into a new fiscal year. For those of you new to state government, we run on a fiscal year cycle, which is not like your regular annual cycles. We start July 1 and in July 30 of the following year. So moving on with Q4, we've issued 24 new behavior analyst licenses. And we didn't do any assistant behavior analyst licenses in Q3 or Q4. No license were issued, excuse me. Behavior analyst interventionists, we issued 279 licenses. And licenses renewed and by paper or online. And online is, as you can see, if you're following along on slide 20, it far exceeds what we do via paper, which is much appreciated here at the office. Thank you very much. And the behavior analysts online, you can see same thing. Thank you to all those folks and the interventionists. The same thing. Online is the new way of getting your licenses issued and renewed. So thank you everybody for going that direction with this. Licenses by analysts, age and gender. As you can see, the vast majority are those who identify as female, and we have males coming in second and others coming in third. Thank you all very much for all the work that you do. Assistant behavior analysts is on slide 24. Again, it appears that the vast majority of these licensees appear to identify as female. And interventionists, it's a good mix, but those identify as female capture the vast majority of those holding that license. Any questions so far? Hearing none, I'll move on. So in the licensing trends on slide 26, the behavior analysts, we run steady between about 490, 494. And those vary because of renewal cycles. Assistant behavior analysts, We've had some turnover, but we're on an upward tick, holding at 20 in Q3 of fiscal year 2025. And interventionists, you can see, is a steady climb and currently on average about 1,734. And your fiscals, you're sitting pretty well at the beginning. Cash balance of $837,655, revenues of $362,621, expenditures of $236,401, net operations $126,220. The ending cash balance just shy of $1 million at 963,876.
Bob, this is Ann. Jamie or Mason, you're new. Do you have any questions regarding, I know we go through this quickly and we use terms. Do you have any questions about the reports?
Not
I
at the
don't.
moment, no.
Okay, thank you very much. Sorry,
Excellent.
Bob.
Thanks, Ann. No, not a
No problem.
And again, the financials are a snapshot in time when the report is run. So it may have changed from June when we had the report run for us. And some of the expenditures, you can see those would, some of the biggest costs would be DOJ bills or regulatory type bills. But the board's sitting pretty well, and we'll be able to sustain any major cases should that happen with this board, and knocking on wood. Fortunately, we haven't had that issue with this board yet. All right. On slide 30 be the regulatory report, and I'm going to turn it over to Trampus Shuck.
Okay. Hello, everybody again. Trampus Shuck here to do the regulatory report. So currently showing up on this regulatory report, there are 2 biennium. And since there's a couple of new people, I'll kind of go over things and also maybe give a little bit of an overview of how regulatory and investigations works with this board. So as you can see on this regulatory report, there's a box to the left that says cases open, closed, and status. So what you see there is you see the 2 biennium, the 2023 biennium and then the 2025 biennium. And the 2025 biennium just ended 11 days ago. So that is a full picture of what's going on for as far as how many cases came in. You can see up on the top section of that little box is the open cases, and it breaks it down into 3 groups: behavioral analysts interventionists, and unlicensed behavioral analysts. So those would be like if somebody was allegedly practicing without a license. And you can see in that open section, there are 3 hanging on from that 2023 biennium. And then you can see the 2025 biennium, there are 10. If you go all the way down to the bottom, that gives you a little bit of a sense of how many came in. So the 2023 biennium, we had 8 investigations come in for this board over that 2-year period. The 2025 biennium, we had 14 come in. Now, I want to say I kind of looked back because I know for a while we were actually getting a lot more cases for this board. And if you could see the biennium before that, which was the 2021 biennium, we had 27 cases come in, but that was a big biennium. So that was kind of an anomaly. So I'm kind of watching this number to see if it stays in the, the 8 to 14, 8 to 12 range, or if it kind of balloons up. So, we'll have to just kind of keep an eye on that and see how cases come in. But so as far as the cases go, a little note about what open and what closed means. Open cases are any case that where, of course, is open. It could have just been opened. It could not even be assigned to an investigator yet, or it could be being investigated. It could be in some administrative review process. It could be waiting for board review. All those kinds of things are open. Once we've kind of have a resolution, either we're going to send out a notice and take some kind of disciplinary action, or or we decide we're not going to. That is when it actually flips over to close. There still could be activity if if we send out a disciplinary notice, there might be a hearing or something like that. And I'll kind of go into that whole thing here in a second. So that's kind of what you're seeing. That's just an overview of how many cases came in, how many cases are closed, and how many cases are still out there being open and potentially going to be the board may be looking at in the future. So complaints by type, you see that middle box. You see some are licensing concerns, some are mandatory self-reporting, some are safety and sanitation issues, and some are services provided. So licensing, it could just be somebody is, their license was inactive and they're working, or it could be that one unlicensed person would probably fall into that category. Mandatory self-reporting is pretty straightforward, but maybe worth a little explanation is, people have to report certain things. If they get arrested, if they're convicted, if certain unprofessional events, they may have to report. So we had 2 of those in the last biennium, people mandatory self-reporting. Probably like I said, it's usually some type of, somebody got a DUI or something like that. Safety and sanitation issues, I think it's just when you look at the complaint, if somebody is saying that sanitation issues aren't properly being going on inside of a clinic or something like that, that those types of things may or may not be under our jurisdiction, but we got a complaint on that. Services provided, that's kind of the bulk of this group. Typically, if somebody is complaining about somebody in this licensing profession, it's about the services they're providing, right? Because that's really what we're regulating mainly, is that the people are out there that have licenses are practicing within certain professional standards. Complainants by type, you can see this was kind of something that we talked about at the last board meeting that we did make a change on, so I think it's worth talking about a little bit more. Complainants by type. So complainants by type, we have anonymous, client, and other. Anonymous is kind of how it sounds like. We just don't have any idea. The person didn't want to be identified. Other is everybody out in the world other than a client. The thing that we talked about at the last meeting was that parents had been grouped as other because they weren't in other boards traditionally the client is the person actually receiving the services, but we talked about it and we felt that it was more appropriate that the parents are also the client. So what I did was I went back and actually reviewed all of the cases that show up on this this report. So all of the 2023 and all of the 2025 cases, those 22 cases. And I just went through, and if it was a parent, I designated that as client. So parents do show up on this report now as clients. So that 4 is a true number. And it means that, and those were all parents, I'm sure. So they were all parents that, that's the number of that were parents. Now you get a little bit of a picture of the 22 complaints, 4 were clients and 18 were somebody else, either an outside reporter or another ABA or something like that was making the report. So that's the overview of this report. Does anybody have any questions about the report itself or the numbers or anything that you're seeing on here?
This is Megan. I just want to say thank you for going back through it and parsing out all of that for us. Thank you.
Yeah, no problem. So I know that some of the board members who have been around for a while probably already know this process, but we got a couple of new people. So I thought I would just really quick kind of go over the regulatory, what goes on in regulatory. So we basically, we're the arm of the agency or the office that deals with enforcement of the standards. So we do all 20, I think it's 20 now. We just got a new program. We deal, so we got people who help the boards and policy help write all of the standards. Licensing gets people licensed and sets them up and tests them and do all that stuff. And then back in regulatory, when something goes wrong or something allegedly goes wrong, that's when we come in. With this board, it's all complaint driven for the most part. Other boards, we have inspection programs like cosmetology. We also regulate and we go out and do inspections. But this board is regulated mostly through complaints. So if somebody files a complaint, says, "Hey, I don't think that this ABA is treating their client properly, or they're not following some standard, or maybe it's something worse than that. Maybe it's some there's some alleged abuse going on, or something like that, or some restraint, overly zealous restraints going on, or something like that. That complaint will come in, and I'll look at it, and basically the test is that if I look at it, or we look at it, and if everything in the complaint is true, and a reasonable person would be able to look at those facts and say that's a violation, or with this board, there's a lot of nuance. So even if I'm not 100% sure, I'll give it over to an investigator. We'll open the case, we'll send it to an investigator. If it's really not our situation, it's not in our jurisdiction, we may refer it to another board that we feel is in that jurisdiction. But typically we'll open them and check it out, just most of the time to err on the side of caution. We do have a great SME that helps us out, and we have a very experienced investigator. We brought on another investigator who's going to help us out with probably these cases as well. So we're going to be so basically, once they get it, they're going to look at it, they're going to check it out, they're going to talk to the SME, which is our subject matter expert, which is somebody in the field who is well respected in the field, and she helps us out with the technical and professional kind of standards aspects of these cases. And they'll start the investigation, they'll do interviews, they'll get records, they'll do all those things, and as long as they still feel that there's something out there, a question out there about a practice violation, they'll continue on. And once we get done with it, they'll turn in their complaint. The SME may submit a report as well, and we'll look at it and go, okay, is there a violation here? If it's really, really clear that there's no violation, we'll probably just close the case. If it's really, really clear there is a violation, we're going to bring it to the board. If it's even a question, like, well, we're not sure, we think it is, we're pretty, there might be a violation here, we're going to bring it to the board. So we would bring those cases to the board. We'd have an executive session. It would be outside of the regular session. It wouldn't be discussed in public session. And we would talk about the case. You would have all the details. You'd have the report. Sometimes you'd have the records, depending on the nature of the case. And we'd talk about it. We'd make a decision. The board would come out and vote as to what the board wanted to do with that particular case. Once that happens, it's either closed or we're going to move forward with some kind of disciplinary action. Then we take it from there. We send out the disciplinary instrument, and it goes out, and we go through a whole nother process. So I just kind of wanted to give an overview of how this administrative regulatory process works, especially for new people who have maybe never been involved in this process. Does anybody have any questions about investigations or that process? It must have been a very good explanation. All right, great.
That's pretty good. Thank you, Trampas.
Yeah. So, all right. Well, thank you. And if any questions come up, I'm still on the meeting. So, and I'm happy to answer questions in between meetings. So you can give me a call and contact me or whatnot. So, okay. All right. Thank you.
Excellent. Thank you. All right. And chair, members of the board, if we're ready, we can move into the policy section of the board meeting, and I will turn it over to Ann.
Thank you, Bob. Again, for the record, my name is Ann Thompson. I'm the policy analyst for this board. An issue, and I brought our new members up to speed during the orientation, an issue that's been going on for a few years now. The board currently in rule adopts the National Association, the BACB's 2016 Ethical Code, chapters 1 through 9. As I mentioned to our new members, the important thing about requiring professionals to follow standards, and again, these are the floor, these are not the ceiling. You can always do better, but you can't do worse, is being able to clearly and correctly outline the requirements. The 2016 chapters 1 through 9 of the BACB Ethical Code did that. They defined how to handle data, how to handle preventing misleading statements, this kind of thing. We cut it off at 9 because after chapter 9, chapter 10 was an individual's allegiance to the National Association. In Oregon, we don't require professionals to pledge their allegiance to an association, so we dropped that part. Well, in 2020, the BACB came out with an updated professional standards and ethical code. And as I explained to our new members, it did move the profession forward in that it addressed some social media issues and just kind of freshened things up. The downside was that it was written in a very prose style, just paragraphs upon paragraphs. Very difficult for regulators to point to chapter 9, line 3 of section 2 that you might have violated. It was very talky. In addition, it had interwoven with its standards some things that were against Oregon's constitution, that were utterly unregulated, we were unable to regulate them. It was not something we could act on. So the board was still interested in pursuing a modernized ethical standards rule. So the DOJ did what we call redlining. And that is they went through the document and they extracted the things from this updated document that were enforceable and were in line with Oregon's constitutional requirements. Because we were essentially extracting information from a piece of intellectual property created by the BACB, we reached out to them and showed them our extract and said, do you mind if we do this? Because they could object. And would it be okay? And if you do think it's okay, we'd like to enter a licensing agreement with you to say that we could use this document and you will not sue us. And surprisingly, our relationship with the BACB paid off and they agreed to it and they did sign. And what you see in front of you today, this is a draft rule that I'm bringing before you today. And the lines, and I was actually thinking while we were talking of the title, Standards of Practice, I'm thinking Standards of Practice for Behavior Analysts and Assistant Behavior Analysts would be a nice addition to that. The line through is what we currently have that would be struck if you wanted to update the language. And everything after that is the extract. Rather than, it would be very difficult for a practitioner to say, hey, we'd like to refer you to the document referred to by licensing agreement. That's not very user-friendly. So we actually put the extract right into rule. And you can read it. You can see that it's divided into sections and subsections with numbers. So if we get a violation, we could refer to subsection C, Roman numeral I, 101 being truthful. It's very easy to follow. It's very easy to cite. So the question for you guys today is to take a look at this. And again, we have a rule in place, the 2016 standards. And now it's up to you, members of the board, to review this, decide if you think that this would be good for practitioners, easy to follow. We would still include, in addition to this extract, we have a rule number 4 that we adopted previously that some of you might remember about the use of restraints. That was something that came forward to the new folks in an earlier board meeting that it was important to the board to have some kind of rule around restraints because that was a very contentious issue in this profession. And the board decided to have this rule where there was no set Like you have to use this kind of restraints. They wanted to allow professional judgment, but they wanted to say, if you do, you need to have a policy in place that you can share with clients and their parents. If an issue comes up about the use of restraints, even if we don't believe in them, we don't use them, you have to have a policy. And if there's an issue that comes up, that you could show us that policy. We were planning on keeping that. That seemed important to the board. Just wanted to make sure that was okay. And now I leave the floor open to the board members. What do you think of this rule? I would caution you, this is an all or nothing. If you want to change one comma, we would violate the licensing agreement. The BACB agreed to this language exactly. It's one of the reasons we did not have a rules advisory committee, because if they wanted to get in and change the language on, Roman numeral 5, delegation of tasks, we can't change one thing at this time, or we would have to go back and get another licensing agreement. This is a first for me, the all or nothing approach. So I've talked a lot. Board members, what say you? I think I've lulled you all to sleep.
This
That was
is
very
Megan.
detailed.
I appreciate all the work that you've done on this. And just curious, on the document, it's crossing out is that with that crossing out of the adoption, the board adopts on number 2 for the standards of practice?
Yes.
Is that what the BACB wanted? Was that
Well,
cross out?
no,
Oh.
thank you. And I should have been more clear. When we are amending a rule, the cross out covers the language that is there now. Right now, we have, for both behavior analysis and assistant behavior analysis, the board adopts section 1 through 9 of the 2016 BACB Professional and Ethical Compliance Code for Behavior Analysts. That is what's in current rule. What we normally do is we cross out what we are proposing to replace, and we follow it with a bold language saying, okay, the crossout is going away. The bold is the proposed new rule. The reason I left it kind of blank, I didn't infuse the bold into the language, was it made it very difficult to read when there was this much of it. Right? When this is all bold, your eyes start to, letters start to stick together, and it just gets harder and harder to read. And also, we thought for the clarity of you guys looking at it, there's specific bold titling, like being truthful, responding to requests. We didn't follow the normal bold for the new stuff because we thought it would just be too difficult to read. It would just be, optically difficult. So the cross out would be the proposed go away. That would be gone. And everything that follows would be the new rule, the new proposed rule that we would put out for public comment. Does that help?
Yes, thank you.
Excellent. Great question. My new board members asked the same. Jamie asked the same question in the orientation. You think I could have brought that over? So what do you guys think? Because we have something in place now that is working. I did a survey. Jamie listened to the last meeting. Kudos to her. I did a nationwide survey and about how different states handle the ethical standards, because the 2020 were a little problematic from a regulatory standpoint. And some states kept the 2016, cut, dried, simple. Some went completely off the map and wrote their own. Some adopted by reference, which is really scary. They just say in their rules, we adopt whatever the most recent BACB code is. Well, that's difficult for regulators, because then they would have to say, how would a licensee know what was in place at a given moment? They don't know when the BACB updates things. A regulator would have to say, okay, well, what was in place when the violation occurred? And that's not very user friendly or client friendly or anybody else, so we say very specifically, this is what we are adopting. That way, licensees know, the regulators know, there's no gray areas. Yeah, some states do a lot of things very their way. So If you don't like this approach, we could keep what we have, which is working.
That's good to me.
Okay. Anybody else? Marie, Jennifer?
This is
Sorry to-
McMahon. This looks fine to me, but I really defer to my my other colleague that work more directly in the field to see if this feels kind of appropriate to them.
This is Jamie.
Mhm.
Something that I wanted to mention. I know that in the service agreement that they're required to explain how you can go ahead and make a complaint to our committee, our board. And just as a parent, I know how many of these I've signed, and there's tons of information in there. And back 7 years ago, my son was actually abused at one of these facilities. And I had no idea this board existed. And it was deep in 30 pages of a service agreement that I could send in something to you guys to investigate. And so I think this looks great. I don't want to have to go back to the other board and try to get a different change made. But something that I've thought since I was put on this board was, I wish I had known back then that this was available to me. And I wonder if these parents who are overwhelmed with their children and get so many paperwork from every single doctor they take them to would benefit from having something separate saying, because it's very important that they really know that this is an available thing to them. A lot of them I know don't know about it. So it's just an idea. I don't know that it has to be changed in here, but it's something that I definitely want to mention in our meeting.
Okay, let me follow up on that. Are you talking about when you say service agreement? We have the supervision agreement, or we have the interventionist presents the parent or guardian with a copy of some information, who their supervisor is, some things like that. Is that what you're referring to, or are you talking about the avenue by which a parent could complain to the board about an issue? Can you clarify for that for me a bit, Jamie?
Yeah, the avenue at which a parent could submit a complaint to the board. And I don't know if maybe that could have something to do with why the numbers have gone down. It's very, I mean, I've probably signed maybe 8 service agreements over the years, and it's nothing that it's kind of vague in most of them. And like I said, I just found out that this board existed a few years ago.
Now
So,
I'm just trying to find out what our avenues are to address that. You say a service agreement. Are you talking about a BACB is creating a service plan with a parent, or are you talking about the interventionist? If you're getting service, are you talking about the BACB, or the licensed analyst and their
well, I think when you
agreement?
sit down with and you wait on a waiting list for so long for your child to get into these places, and so you sit down and sign all the paperwork with them.
Oh, like the behavior plan and that kind of thing?
That you're going to be agreeing to send your child to this place, and and all of kind of and in the service agreement it says that. So it basically, talks about, it needs to talk about the guidelines for complaints about behavior analyst professional practices under the service agreement. It's kind of, I think it should be very clear to the clinics that they need to make a point to let these parents know if there is something that has gone on, how they go about doing that.
Okay, that might be a separate conversation from this rule. Marie, what do you think? What is your thought?
I I don't know if it belongs in the rule or not, but it sounds like that is something similar to like what you find like in a HIPAA informed consent and confidentiality.
Okay.
That's kind of
Okay.
sounds what you're she's talking about.
Okay, Megan?
Yes. So every ABA agency usually has their own service agreements that they do
I
prior
see.
to starting services. And so that outlines what the services will entail for the families. And they are very lengthy documents usually. And I will say they don't always get different people have different rules. There's not like a standard of like how much to go through it with a family. And I wouldn't say that it is, I wouldn't say of the agencies that I worked for that it's standard practice to reference the Oregon board, because a lot of these agents, a lot of the companies are not from Oregon, they're from various other states. So I will say that's probably maybe not in this rule, but something that we might look into later of addressing like how to properly inform, having
Okay.
agencies properly inform families about the state process of regulation, because I don't think that I think that we're informing behavior analysts, but we're not always informing families of that.
Okay. If I might, because we got to stick to our agenda. If I may, Jamie, can we put a pin in this and maybe bring it up on other board business at the end of the agenda? And what that will do is allow this to kind of percolate in people's minds, kind of get some ideas, because I hear what you're saying. I don't think that the issue that you're mentioning could be addressed here, because this is the ethical standards that analysts have to follow and kind of professional standards. I think if we get into sort of the information part of service plans and things, that might have to be addressed in a different place. So could we put a pin in this and bring it up at the end of the meeting, and we can possibly brainstorm some ideas?
Yeah, I'm new to this, so
Absolutely.
thank you for listening. And
course.
whenever we should talk about this would be great.
Okay, well, but it's great because this allows the practitioners to kind of think about the paperwork and the process. But as Megan said, we don't really have any authority over companies. We can't tell them what to do. There are certain things that they have to do, such as the competency assessments and things like that, that they can, as long as it has the information that the forms that we provide have, they can put it on their own letterhead or whatever. But we can talk about that in other board business. Certainly. So if everyone could kind of put their thinking caps on in that direction. Thoughts about our rule. First of all, if we don't have any specific thoughts about it, is this, I guess the easiest thing for me to do is to ask, is this an update to rule that you think we should pursue? Because we can still back out at this point. This is the draft. You wanted me to provide you with work. Here it is. Do you think moving forward in the rulemaking process with this rule is a good idea?
This is Megan. I think I know that we've put a lot of work into this over the last year. I think that it makes I'm completely fine with moving forward, especially given that we have the BACB. I forget what you said, licensing agreement or whatever. I mean,
Right,
that's huge because that was such a huge problem initially.
Well, it was, but at the same time, I want you all to feel empowered to say it doesn't matter how much work it took. If it's not the right thing, it's not the right thing, right? Just because something takes a lot of work doesn't mean that it's right. So if you feel that this does move the profession forward and you want to keep going, that's fine. But the licensing agreement doesn't mean that we have to go. You guys are in charge. If you thought the other one was more clear, more easy to use, that's still on the table. It's just completely up to you. And I told the BACB, I wanted to bring something to you guys that if you wanted to say yes, that wasn't going to be a stumbling block. So I got their pre-yes before I brought it to you. Doesn't mean you have to go forward. So it's completely up to you. But if you like it, you like it. What do you think, Jennifer?
I like it. I guess my only concern is the things missing. And I know there were things that, were like the allegiance to the BACB and stuff, but some other items that are missing that I would consider important, but also could just be like a real headache is what I'm guessing, as far as like regulating. So I guess that's my only concern is like those missing pieces.
Is there something specific that you're referring to?
Sorry, I'm trying to go between documents and
That's okay.
and find the unmute button. Let me the multiple relationships, giving and receiving gifts, coercive and exploitive relationships, those sort of things.
Okay. I'm actually looking through that myself. Bob, you had your hand up?
Yes, thank you very much. And thank you, Jennifer, for the clarification. In the document that we're discussing, in item 4, it talks at the very bottom about ORS 676-612 2J. And there may be, if what you're thinking, such as unprofessional conduct, negligence, incompetence, repeated violations, those types of things, is that what you were thinking of? Because then we have it covered here in 676-612.
Okay, I'll take a look at it.
Oh, it's okay. Maria, I see your hand up. 1 second. The thing is, Bob, with this profession, multiple relationships is a very ongoing issue because of the service model. We do talk about in section 2, little h, the board adopts the definitions of the following words as they are defined in the glossary section of the Behavior Analysis Certification Board Ethics Codes. Client, behavior change intervention, informed consent, legally authorized representative, multiple relationships, research, scope of competence, and third party. So we do have that here. Marie?
Thank you. And I'm just sort of clarifying, you had talked before about the issue of restraints. Is that something that would go? I'm just trying to understand it. Is this what we are seeing is just what we are taking from the national board? I guess it would be helpful for me to see what the entirety of it would look like and sort of understand where, what it is that we're borrowing.
Okay, that went out with that was at the last board meeting, that giant document.
Right. But what I mean is that I guess just being able to sort of clarify, it's just harder for me to, I think, know, like, does this look good or this doesn't look good, or what is missing? I'll go back to those other documents to look at.
Oh, no, it's totally fine. And the reason I called out the restraint rule was it is staying in the proposed rule. We are keeping number 4. If you look to the bottom, I think it's slide 37. This would remain, which says licensed behavior analyst and licensed assistant behavior must have a policy in place regarding the use of restraints. Copy of the policy must be given to the client's parent or guardian at the beginning of the service agreement. The policy be one piece of information considered by the board or office in determining whether a restraint used on a client constitutes unprofessional conduct, negligence, incompetence, or failure to conform to standards of practice. We do have a statute. Bob actually referred to it. ORS, Oregon Revised Statute 676-612 2J. And that is one of our go-tos when it comes to unprofessional conduct. That statute outlines the whole world of unprofessional conduct, and we refer to that when we're doing investigations in these areas.
Okay, so it sounds like I was confused. So I'm just again clarifying that what I am looking at is the entirety of what the ethics code would be is written.
Yes. Instead of If you recall, I think we had about a 225-page
Yeah.
materials packet
Oh,
last
yeah.
time
Mhm.
because the 2022 code was many pages, and it was written in that paragraph form. So our attorneys had to go through and pick out the sections that
Yeah.
were A, enforceable, and B, didn't conflict with Oregon law. And this is it. It's almost like, rummaging. I use the analogy like a pot pie, and they went through this pot pie and picked out all the peas. And this
Okay.
is it, right?
Okay.
And if you're not ready, and I mean, don't let our enthusiasm or momentum affect you. If you want time to look at this, I can send out to the board the unabridged code, and you can keep this in materials, and you can certainly ponder this. We're no hurry. We have a code that's holding, and we can address it at the next meeting, and you guys can read the long form, read this, see what's missing. If you feel really strongly that there's something that you want to add, we can go back to the BACB and say, our board really wanted to add this. We can consult with our DOJ attorneys, and we can bring you something else at your next meeting. Jennifer?
Yes, I just wanted to say I saw the part too. I don't know, like I must have missed it before where it says that, we adopt the following guidelines. And so I was just reading the guidelines that were like picked out there, but see that most of the others that like I was concerned about are written under 3B, just explaining that we also adopt the other guidelines.
But really, if I've not brought this to you in a digestible format, tell me how I can do it better, and I can bring it back. Because I want you to be very confident in your decisions. Any thoughts, Bob, Tina?
I'm going to defer to the board. They are the professionals in
They
this
are.
arena. And, if they say we need to do more work, we'll happily do more work. But again, it is what they're seeing in front of them. And I'll just reiterate what Ann's already said. What's before you is what was agreed with the BACB. But again, what Ann said is we can go back, do the work, and go back and get reauthorization from BACB to change.
Yeah, we'd have to work with our attorneys. But if you really feel something is missing, if you feel that this is not moving the profession forward, if it's not clear enough, if there's, like I said, it doesn't matter the work done. If it's not done, we can keep hammering at it until you have something that you like.
This is Bob again. Also what Ann said, I'll reiterate it. Yeah, if you want time to digest it and do some comparison, let us know. We do have a rule in place, and it's not going anywhere until we replace it.
Yeah, and I'm happy if this, especially since we have some new members, if you want to take this material, I can send out the unabridged that this was extracted from. And I apologize, I've been living in this so long, I missed sending that out again. I can even send out a copy of the current 2016 standards to the new folks, and you can look at the new one, you can look at the old one, what we have in place, and continue to think about it. If you're having second thoughts, or if you want to ponder it longer, there's no harm in that. We encourage that. We want right is more important than right now. So if we're feeling like we want to go that way, just let me know, and we can take it up again. It's an important thing. So Chair, what would you feel? Oh, we have Jennifer. Jennifer, what would you like?
I was just gonna say, I think more time would be good. Like
Okay.
personally, I'm going through and kind of like highlighting what's missing and
Okay.
what. So yeah, more time would be great.
Okay. Does anyone else agree with Jamie or with Jennifer? I apologize.
This is Megan. I agree with that as well. I think especially with having a few new members and whatnot, I think it would be great to have some more time to review it. And then I had one other question. I know we often send things out for public opinion sometimes. Have we done that with this already? Or
Actually,
is that later?
No, the way it would work, the public is definitely consulted. Traditionally, if it's at all possible, what we'll do is we will bring a draft to what we call a rules advisory committee. And we would select people, we would put out, a call, say, would you like to participate in reviewing these proposed rule changes? And we get consumers and we get insurance companies or we use our imagination to think of anybody who could possibly be affected by this rule. We did it for remember the interventionist professional methods and procedures rule not too long ago. And we had a wonderful group that all came together from everywhere and they hash it out. And I bring the results of that to the board. And then you would weigh in on it and adopt proposed rules or make changes or whatever. We couldn't do that in this case because of the licensing agreement, the 100% all or nothing. If we brought this to a rules advisory committee and they wanted to add something or change something, it would violate the licensing agreement. That's that 100% all or nothing thing that I talked about. So we are bringing it straight to you. We got a rules advisory committee exception based on the licensing agreement. And so we're coming straight to you. What we would do is if you adopt proposed rules, and remember, at any moment, we can stop because we do not have like a legislative mandate to fulfill. We could adopt proposed, and then what we would do is post this in the Oregon Bulletin, notify interested parties and licensees, and send it out. And that's when we open what we call the public comment period. And then the masses would look at it, review it, and send me their comments, which I would collect and bring to you during the public comment period. Now, if everyone says, no, this doesn't work, you could just pull the plug. You don't have to adopt a new rule. You can just say, we're going to go with what we have based on comment. So that would take place, but it would require adopting proposed rules. If you're not ready to do that, I mean, you could and start the public comment period and see what people think. If you want to take a little bit more time to digest the source document with what we're showing you before taking that step, that's another thing that's on the table for you. So it's all what you need at this time and what you're comfortable with.
This is McMahon. I think I'd like a little bit more time to digest this and kind of look at,
Okay.
And just refresh my memory.
Okay. Because it is a big read. I will tell you, this source document is a very big read. So if it's okay with everyone, the message that I'm getting is that members would like a little bit more time to digest this. So what I can do, if you're okay, everyone got these materials. If you're okay with keeping this, I can, after the meeting, have Josh send out the source document as well as the 2016 standards that are currently in place. And you can look at how they're laid out and how they're worded and just ponder. And we can come back to the next meeting and see how people feel. Are we comfortable with that?
That is perfectly fine with me.
That sounds great.
Okay, so Mason, it sounded like you were a little garbled, but it sounded like that would work for you?
Yes.
Excellent. Marie was okay with that. Any other thoughts? I appreciate this is a lot. Megan? I saw your
I was just
bubble.
going to say, I think that sounds great. Thank you.
Okay. So just for the record, And if you need another copy of this, let me know. After the meeting, you will receive the 2016 standards that are currently in place, chapters 1 through 9. You can look at them. And I will send you out the 2020 BACB source document, and you can ponder, and we'll come back at the next meeting and decide on next steps. So we are not going to take a vote. We are not going to have to worry about the rule schedule because all of this is now tabled, and we will see it again. But I appreciate the thoughtful approach. Again, I always believe right is better than right now. And so we're not going to need to vote. We're not going to be talking about the schedule. And with Bob's permission, we can move the discussion to the next item on the agenda, which is licensing.
Thanks, Ann. I just wanted to bring up one thing mostly for the new board members. If they're reading the proposed rules and they have questions, would you prefer them to send you the questions so you can have it prepared for the meeting, or would you prefer they hold on to them until the meeting?
Oh, just reach out to me with any thoughts that you have or questions, and I'll guide you. If it's something that I can just talk to you as a person, you worry about procedure or what do we do next. But if you have questions that you think would benefit the group, please send them to me. If you think you want to put them on the agenda, if you want me to, be the keeper of your ideas, I can do that. Just communicate whatever you have to me, and I'll decide if we need to put it on the agenda or if, just let me know what you're thinking of, and we'll figure out how to craft it and get it into the discussion.
Thank you, Ann.
Of course.
All right. Chair, members of the board, if you're ready, and if Tina Russell is ready, we can move on to the next item on the agenda, which is the licensing piece.
Good morning, everybody. This is Tina. So I wanted to bring to the attention to the board regarding electronic signatures and wet signatures. We have had an influx over the last year or 2 years of electronic signatures being sent in on applications for interventionist. And when something's missing on an application, we contact the interventionist, not the supervisor, not the company that's are sending in these applications. So we contact them when something's missing, only to be greeted by one that we're scamming or we're fraud or or we're being hung up on, etc. So what we did is we decided that we were going to send a email to all the supervisors in Oregon that we had on file and let them know that from here on out, we were only going to accept wet signatures on the applications. That way, the applicant themselves are filling out the application and are aware of who HLO is and aware that they are having applications sent to our office. So as I was talking to staff this morning, evidently these emails have helped quite a bit on having wet signatures, and the interventionists are aware when we call them to get additional information. So we're hoping that this is a solution that's going to take care of the problem. But we have other things that are happening too, that these companies are also renewing for interventionist. So on our renewals, they have to say whether or not they are either on probation or parole, or if they've been convicted of any crime since their last renewal. We don't know if the interventionists are the ones filling out these forms or not. We're hoping that now that they have to fill out their applications and do a wet signature, that it will inform the interventionist a little bit more as to what the laws and rules and regulations are for renewing or filling out applications. Bob, did you want to add something?
It was just a clarification with what your staff are greeted with when they call. One of them that sticks in my mind is the most concerning is the applicant is it if I remember correctly, applicants were saying, I have never applied for a license.
Correct. Yes, you're correct. That's what they were telling us. So that only means that the supervisor or the company that they're working for is filling out the applications and sending them to the health licensing office. And that there in itself is a problem.
If I may, Tina, I've been kind of working with Tina and Bob on some of these issues board. This is Ann Thompson. And one of the more alarming uses of electronic signatures, because I know the companies call me and they're saying, we have supervisors who are using telemedicine and they have to sign off on the competency forms and they have to sign off on the supervision forms. And there's all of this signing and it's so inconvenient. And they're, what they usually say is we're trying to get services out as quickly as possible. And we understand that. But it wasn't too long ago that a very big company, and I'm not going to say who they were, we found out that they were using a BACB's electronic signature on interventionist documents after she left. And that she really was transferred to another part of the company and they were still using her signature on documents for people she was not supervising. And this really makes our hair stand up as regulators. And we wanted to talk to you and Tina was, we try to extend every courtesy that we can. We understand slow processes, and wet signatures are a slow process. And we're looking at going into electronic applications. But again, that would be an electronic application sent in by an individual to the health licensing office. What makes this difficult is we've got third parties sending things on behalf of other individuals. And the use of electronic signatures can make that really, really messy. I hope that was helpful, Tina.
Yes, absolutely.
So we'd love to get your thoughts, Megan, and some of your practitioners. Can you help us, if there's anything you can say or any policies that we should look into? We've had to go back and revert to the wet signature, but do you have any thoughts on some of the issues we've been having?
This is Megan. I've worked in a school setting for a number of years, so it's different. We don't have quite the licensees since working in clinics, so it's been a bit since I recall that. But I do know that, just for understanding the process, it doesn't excuse it, but usually what happens is a lot of these families will be on waiting lists for a certain period of time, and the company or the supervisors or the BCBA, whoever, depending on the company size, will get an applicant to hire. And then they usually have to do the 40-hour trainings, all that stuff, because most of them are brand new to the field whatsoever. And so they have to get all that stuff through before the kid can start receiving any services if they don't have any staff on hand. And so I know that oftentimes there is a big push to try and get that through as fast as possible. So I would imagine that's where some of that is coming from. And then from an interventionist standpoint, most of them are young and not full. They don't always fully understand the process, I think, sometimes. And I don't think that not every company explains it very well for the interventionist. So I can see where this can go awry in some of those situations. And then obviously, not everyone has the best intent as well. So I'm sure there's some of that as
well. And if I may, and Chair, This is Bob. One of the issues with some of that is the applicants are signing, attesting and swearing to the validity, the information that's contained within. So on a regulatory standpoint, if there was a complaint and the applicant is not the one who signed the application verifying some of the information, that applicant is going to be held responsible for what the contents of that application is. And I will say that some of the applicants have come in without social security numbers, and that's the biggest concern that the applicants express to our staff when they call and say, hey, you filed this application and you didn't put your social security number in, and they tell us, I never filed an application. This is a scam. I'm calling law enforcement. So there's a lot of ramifications in the individual applying for the license actually not filling it out themselves. So I'm not sure what the best way to do it is, because I know time is money for the companies, but something as simple as when they do the 40-hour course, make it 40 hours in 20 minutes and have the applicants fill out the application. The interventionist fill out the application. I don't know. So anyway, Marie.
Yeah, certainly I would have a concern about fraud, right? I feel like that you sign something for someone else on a legal document, that is fraud, and there's obviously some ramifications to that. So I think on the other end, and it's probably a different discussion. What happens then with these companies that then we know are signing for people? And I think given what sounds like the bad actions, there are some bad actors, and I don't think that that's representing the entire field, but it does sound like having that wet signature. I think it also underscores the importance that this is an important job. People have to take the time, and it takes the time to get that wet signature. Then you do it.
I agree. And you're spot on with the ramifications of the applicant not being the one to sign it with the fraud and so on and so forth. And that's what they're alleging against HLO. So thank you very much for recognizing that. Jennifer.
I guess my main concern that was already brought up is that a lot of our field is going into that like telehealth, and especially for our rural areas where there aren't many practitioners, that's a really been a great way to serve those clients that otherwise wouldn't be getting services, and it could be really difficult to get those wet signatures. Or maybe it is, I mean, can they just sign and then like scan and send it back to them?
Yes.
Or does it? Okay, so maybe it's not as hard as all that, but that was my main concern. And then just echoing what Marie said, just like what are the consequences for the fraudulent behavior the companies, and maybe is there a way to make that more clear to them, because it's really concerning that this is happening.
I'll call on Tina because she's probably going to answer your question. Tina.
Well, can you repeat that one more time?
Yes,
go ahead.
I was just asking, like, what are the consequences for the company for engaging in that fraud?
Well, Bob, well,
on that note, the consequences could be huge against the company should a criminal complaint be filed. That's not HLO. What we're doing, and I'll let Tina reiterate what I'm going to say now, is we're working with the companies. Tina's had multiple telephonic meetings with the companies. Tina, go ahead.
Yeah, some of the concerns are when you hire an interventionist, aren't they coming into the offices to, one, fill out their application, one, to do some kind of a sit down, what their job description stuff are? Or is this all through emails. Are these companies hiring these individuals just to hurry and place them? They have to do their 40 hours, then they have to be supervised. So help me understand a little bit about, one, do they ever go into the office? If so, I mean, they have to give 2 pieces of ID when they fill out the application. They should be filling out the application. Supervisor should not be filling out the application. We've seen applications that have actual handwritten on the top for their name and address, date of birth, social security, but then the rest of it is all electronic and then electronic signature. It's almost like they fill out part of it, then the company fills out the rest, sends them into us with the payment. Let's bring up one other thing. These companies also feel that since they paid for the license, that when that individual is let go, that they should not be able to have that license any longer, which is not true. Once the interventionist fills out an application and pays the fees, that's their license. That license is for them to go on to another business. It's not to stay with the company. So, I mean, there's several problems, issues going on with the interventionist.
This is Parnum. I can maybe help you understand. I'm going to do my best to be non-biased, but I think ABA as a field has a whole lot of companies that are owned by private equity that are in different states that don't have the most thorough hiring processes. I think the answer to, are the interventionists going into the office at least 50% of the time? No, they're not. There are times where the interventionist maybe only sees someone else from the company once a month, and that's being generous. So it's not, I think this information isn't new, if that makes sense to us. Like, we're kind of used to it as clinicians. So I don't know if that helps answer any of it. But these giant private equity owned companies are not the most thorough.
Okay.
This is Tina. So if an interventionist is in Oregon, could the company put on the interventionist that they need to apply and get their license at the time that they're doing, or have those discussions with them, that they do their training, then they apply themselves to get the license?
Could they? Yes. Would they? Maybe. I don't know that getting some of these kind of, especially the out-of-state companies, to do anything different is a very easy process as someone who's tried from the inside. So I don't see why they couldn't.
This is Megan. So I also wanted to, similar to Samantha. So a lot of these larger companies, your interview with the company is virtual. They send you paperwork via email that you fill out. And then their 40 hours, they use a free online course that's all digital and not great. And then they go in the field, and then they meet their supervisor maybe for the first time at that point. So there's not a whole lot of oversight with a lot of that. And I think that's one of the issues that I think comes up a lot with the board is we don't govern companies and those bigger entities. And a lot of times they're choosing to do some of those practices that are maybe not ideal and not great or borderline unethical.
Marie?
I'm like outraged. I understand that this sort of thing happens, and I just feel like if someone is going to do something that's basically commit fraud, by signing on behalf of someone else. And that's, there are ethic, but there's legal issues there too. I don't know what else is going on too. And I feel like at least one thing we can do is require that there is a signature, there is a wet signature from someone who applies. I think that that's the issue that we're talking about today. And yes, there absolutely should be a wet signature on that. So I'm sad to hear about just how other things are happening, but it seems like the most basic thing that you can do is require people to sign something themselves for their own application. And at that it may require, I know for my own licensing, you initial off on certain things, like, I've never been convicted of something. So I would say both things, a signature and initials for that information, so that someone else is not doing it.
Thank you. It makes me feel good to hear from the board that HLO's on the right track, with requiring the applicant to sign the application with a wet signature. And I heard a little bit, and another thing that kind of concerns us at HLO is you have a person that's going to be working with an individual with some sort of disability or with disabilities, and the person can't fill out an application. That to me, that's pretty concerning and alarming. But like I said, we are working with the companies to get them to understand and work with us. It sounds like it's becoming more. It's getting better, but we wanted to bring to the board the issues that we're having, because I also hear in other arenas that it's taken HLO too long to get these done. It's, we have a statute that requires us to issue a license within 5 days after the application is completed, and so we've had to educate companies on that, on what a completed application is, what the definition is. So, yeah, it's been a lot. It's been a long road for us, and a lot of contentious moments, but I think we're working through it quickly. Tina, I see your hand, and then Ann and Adrian. Go ahead.
Yeah, I just wanted to say exactly what you said, Bob. And it has taken us a while, but we are ironing out the problems. And hopefully now that the supervisors know they have to be wet signatures, we won't be getting as many hang up calls or individuals being upset with us when we contact them, because we don't contact the supervisors when something's missing. We contact straight the individual that applied. So, yes, we have definitely had some heartaches over the last couple of years, but things are getting better. So thank you.
Ann?
Yes, thanks, Bob. I will ask the board for some guidance on an issue that hasn't been touched yet. Occasionally I get calls from compliance officers, attorneys from these big companies that you refer to, who find it inefficient that the supervisors have to sign on the competency assessment and the 40-hour training and that kind of thing. And they want to use electronic signatures. And I would like to know your thoughts on that, because I've heard the supervisor is via telehealth. And so the signing and it's all very inefficient, and it's slowing down service delivery. So we've talked about the applications, but what about the obligations? What are your feelings on the obligations of the supervisor? Because my question was, you're signing off that somebody is ready to provide independent service delivery. Have you even met them? Have you actually looked at them? And it's that hands off, well, we do, and it's all very inefficient. And I said, well, if you sign something, you're putting your license on the line. You're saying, I'm saying that this person is competent to provide services to a child who might be nonverbal. And they were pushing for electronic signatures at the supervision level. Can you give me some words or some feelings how I would address those kinds of complaints? Marie? I'm sorry, Marie, I can't hear you.
Because the supervisor is legally responsible, that supervisor must provide the signature for it, and a wet signature is the best way. And
Okay.
I'm sorry that takes a long time, but that's also just the law in a lot. We don't sign for other people.
Okay, that's good guidance. With no other
This is
hands.
Parnam.
Oh, yeah, please.
Sorry, I can't raise my hand on my phone. I just have a quick question because I think you mentioned that people are complaining about how long it takes. Is that, did I hear that right? Okay, as
Correct.
someone who owns a company that does services in Salem and Clinic, we don't have any problems with that at all. I just checked with my person who does our licensing, so I don't know that feedback is necessarily completely valid. I'm sure it has, some validity, but all of ours are processed fine and quickly. So I don't know if that's helpful or not.
No, it's very helpful, Samantha. Before I cede the floor to Adrian, who is the person on the front lines of applications, it has been my experience that when something has gone slow, it's because, say, a company sends in applications for 5 interventionists. One person drops out of the process. They want to apply this application to this new person. They send ID for the wrong applications, the wrong people. Yes, that will definitely slow the process down. Adrian, do you want to elaborate?
Hi, thanks, Anne. My name's Adrian. I'm the qualification specialist. Anne, I want to address the electronic signatures on the 40-hour training form and supervisor form. I believe one of the reasons we were doing wet signatures, oh, sorry, my headset almost popped off, was that was one of the documents that was being forged it was being listed as one trainer when it wasn't that trainer providing the training. So that form specifically is one of the reasons why we moved to wet signatures. And then I don't know if possibly an idea to help with the process is at this time, there's no process for anyone to apply to be a supervisor. They just have to hold a behavioral license. And then I receive an application from an individual and their name is listed as a supervisor. That's it. Maybe a way to smooth out this process would be for if someone wants to be a supervisor or trainer, we have a form for that they send in so that I can provide them maybe a document that provides the proper procedures for submitting applications so that when someone wants to supervise or train, they are providing the information from us on how to provide, on what information they need to ensure to be providing to their trainees, including how to submit a complaint if needed to the applicants. I know someone had mentioned that earlier, that family members aren't provided our office information for complaints on, I think they said their service agreements, freelance licenses in our office. They're provided information that they have to provide our office's information for complaints. So maybe we can let supervisors know that in their service agreements, they need to provide HLO's information so family members are able to make complaints. Sorry, I had a lot of stuff. I was holding my hand up. I think that's all I had to share, but let me know what you guys think, and thank you.
Thank you, Adrian.
Thanks, Adrian.
Marie.
I just want to see if I understood what Adrian was saying. Are you saying that there are supervisors that are not licensed in Oregon that are signing off, or
no, we've had all are you talking about the forgery documents? I know that we had some that they were licensed, but they were not in that location at that time performing the services.
Okay.
They were just using their electronic signature and putting in all the training forms. So
Okay, but they
we
are
don't.
licensed in Oregon.
They are licensed in Oregon, yes,
Got
but
it.
they
Okay.
were not the individual providing the services.
Got it. Okay, thank you.
No problem.
This is Ann. I think Adrian's onto something, and I think that maybe an FAQ, we could put something together. The complication with the supervision in this particular board, the statute that created this board allows a list of professionals to supervise interventionists that HLO has no authority over, including occupational therapy, professional counselors, medical, nursing, physical therapy, speech language pathology, social workers, and the Board of Psychology. All of those professionals, licensed professionals, could technically have interventionists working for them. We have no authority over them. So I don't know if the idea of having people apply or to be supervisors would work, but we might be able to come up with like an FAQ document that we could send out. That's certainly something that we could work on and develop. That was a great idea, Adrian, and maybe something that we could come up with. Don't forget, best practices. This is what we're going to need from you if the board thinks that would be helpful.
Yes, that sounds great. Thank you, Ann.
Jennifer?
I just wanted to say, I think that sounds incredibly helpful. Good idea.
Adrian's an idea machine. I don't know how we function without her. Today she's not here.
I appreciate you guys.
They're not
Ann
gonna be able
helps
to
me.
live with her
Ann's my
now.
backbone.
Stop. No. And Adrian's on the front line, so she gets this every day. So I could work, if the board likes that, that might be something that Tina and Adrian and I could put together, put it on the website and maybe send it out with, a packet of information, just attach it and say, hey, don't forget. And, maybe we can change things that way.
I will work on all of that. Just let me know where I need to be. Thank you.
Thanks, Adrian. Okay. Chair, members, if there's nothing else with regards to the licensing issue that we brought forward, that was just to make the board aware and to obtain ideas and a better understanding of what happens out in the real world outside of HLO. If the chair is ready, and we can go into public and interested parties feedback.
Sure. At this time, the Behavior Analysis Regulatory Board will hear public and interested parties' feedback. Public comment is limited to matters listed on the meeting agenda or topics relevant to what the board has statutory authority to regulate. Comments will be limited to
Typically 3 minutes, Chair.
Thank you. 3 minutes, and will not be allowed if they are disruptive to the board's conduct of business. If you're called on to comment, HLO staff will request the public member to unmute themselves. The chairperson and the HLO reserve the right to end a person's comment early and have the HLO staff mute the public member if the comment does not pertain to matters listed on the meeting agenda or topics relevant to what this board has statutory authority to regulate. Are there any members of the public who wish to comment? If so, please raise your hand or use the MS Teams raise hand feature and wait to be acknowledged.
Chair, this is Bob. I see Taylor Menendez has their hand up. Taylor, if you'll take yourself off mute, please go ahead.
Hi, thank you all so much. I wanted to just make a quick comment regarding the licensure requirements with the signature. I work for Positive Behavior Supports, which is one of the large companies providing ABA services in Oregon. And so I just wanted to make a couple comments regarding the signatures. First and foremost, fully agreed with the legitimacy concerns regarding the applicant. They absolutely should be aware that their application is, they should be sending it in. We don't send them in on behalf of users. They should be sending it in. And I do agree that the wet signature from the applicant does help with the legitimacy of the application being sent in. I think that it might even be helpful to have something. I know that the email sent out to all of the supervisors did say that the applicant should be aware and they should be filling it out. But maybe even having something on the application itself stating that this needs to be filled out by the applicant could be helpful with that. I did want to mention the concerns regarding the e-signature for supervisors. So we do have some concerns with that just because we're the largest ABA provider in the state of Oregon. We provide services in the Portland metro area, Southern Oregon, Eastern Oregon. We're on the coast, we're in Central Oregon, we're all over the state. And once again, we do provide services to a lot of rural families where maybe the supervisor is providing that telemedicine support 2, 3, 4 hours away from where that applicant lives. And so as part of our onboarding process, we do have a dedicated leadership member that does do all of their 40-hour training. We provide that individualized support, that like hands-on support for those applicants. But because we are providing services potentially 8 hours away from us, we do not have an office where our applicants can come in and we can sign the forms with them. We do everything online, but that doesn't mean that we don't see them, right? We do still see them. We are still face-to-face with them. It is just not in person because we can't, because we're providing services so far away. So that is one of the reasons why you might see the name of a supervisor on an application that might not be their ongoing supervisor, because we have a dedicated team member to providing onboarding individualized support for that person. And so we're kind of concerned regarding the wet signatures just for supervisors. I do hear your concerns. I wasn't aware that there are companies using signatures for supervisors after they're there. That is absolutely a concern. But I'm wondering if the board has considered utilizing some type of like verified e-signature or something like that. There are ones that have like timestamps or things like that to make it easier for the supervisors to sign off, and then still requiring the wet signature for the applicant, because once again, they should be aware that they are applying for their own license and it is their license.
Taylor, excuse me,
well.
Chair.
Yes.
And Taylor, sorry, 3 minutes are up. If you
No
could, if you don't mind, if you have your comments scripted out, would you be so kind as to send them to Ann Thompson, and she can share them with the board, and then we typically don't have in-depth discussions during public comment. It was just public says what they have to say, and then we take it into consideration and speak with the board. So you're at your 3 minutes, and it pushes us into ethical issue
No
with
problem.
the Oregon Ethics Commission. So,
No problem. Thank you.
And thank you so much for letting us know and sharing that information with us. Is there anybody else in the public that would like to make comment? Okay. Seeing no hands. The next item on the topic would be other board business.
Okay, this, if I may, Bob, this would be, we would relocate the conversation about letting parents and clients know about the existence of the board and how to do that and get that into people's hands. Like, I'm sure Jamie has heard, it's not something we can force companies to do. So we were going to maybe brainstorm ideas from Jamie and maybe from Mason or the other practitioners. How is it best that we can communicate to parents about the existence of the board and the complaint process, or any other way we can support the clients? Jamie?
Yeah, I think the reason I brought it up while we were talking about the standards, because I was thinking maybe there was a possibility that in that 3.04, where it talks about the service agreement and it talks about the guidelines, that we could have been more specific about how to notify the parents. But I guess that may or may not be something we can do.
Well, the rule specifically, we talked about how words matter in the giant dictionary. That rule is aimed specifically, I see your hand, Samantha. That rule is aimed specifically at analysts and assistant behavior analysts. And it's about professional standards and ethics. And I'm not sure if we could enter the service agreement space with that. The hand? Is that you, Samantha?
Yes, it was me. I just had a thought kind of related to that because I think it's a really good idea. I think that a RABA would probably be the best way to get that out. So it might be worth reaching out to the people in Araba and sort of present that issue and see what they can come up with because they're responsible for, services in this state. So that's probably the best way to get it addressed, I think.
Okay, so that's the Oregon Association for Behavior Analysis. That's the association that advocates and represents a behavior analysis in the state for our new people. So the idea that I heard was to reach out to them and see if they could communicate to their members that about how to let parents of clients know about the board's existence. Did I capture that correctly?
Yeah, I think so. I think that I think it should probably be like a more coordinated process to make sure it's accurate. But I definitely think there's a lot of room for improvement in what information parents are given, about how to complain and all of that. So yeah.
Okay. So communicate through their membership to let parents know about the board and the complaint process.
Yeah, maybe come up with some guidance documents that say if you're going to do business in the state of Oregon, here's maybe sort of the bare minimum you should give to parents, because it definitely varies across agencies, which I think leaves parents in sort of a black hole of information. I know we tried for a while to kind of get a group together in Salem that could advocate for best practices and, talk through what good, in quote, services should look like. But we didn't get very far. But it's definitely an area that needs to be addressed, and they are probably the best way to get it done. I thought.
Okay, I see your hand, Marie. The difficulty, and that's a great idea, and I appreciate the feedback. The differences between an association and a regulatory board are that an association promotes the profession and pushes for best practices, and a regulatory arm enforces minimum standards. You can always do better, but you can't do worse. And so we have different roles to play. So I would have to see kind of how we could work with them, or even, we could send out a message to our licensees. We might want to do it ourselves, but we'll see. Maria, what are your thoughts?
I was wondering, as far as that parent information, I wonder if an organization like the Autism Society of Oregon would be open to having some information just about, how to, just what people rights. And so that it may, it could end up that ASO would be interested in doing as part of a larger thing to say, like, also, like, here are your rights when you're, it could be general or it could be specific, but I think that would be a good way to reach a lot of people. I don't know what ASO's, response to that would be, but putting it out there as another way to let parents know about just their rights and ways of accessing things.
Yeah, Autism Speaks was very active when we were getting this board off the ground, and representing the client experience and the patient perspective. Megan?
Yeah, I was thinking, I feel like putting it out to licensees would be better because there's there are people that are licensed in the state that are not members of ORABA. So I
Yeah.
think you would be hitting more people than disseminating that information to ORABA to send out.
That's actually a great point. Again, part of Oregon Constitution, and we talk about I don't want to put you to sleep, but the unconstitutional delegation of authority. And what that's saying is a regulatory arm reaches out to an association for private, maybe, or, public or whatever, and has them do a regulatory function for them. And that is not how Oregon operates. So that might be something we can just distribute through our own, and our interested party list includes some of those organizations. So that might be a communication that we send out. And the big message, if I can clarify it, is how a complaint, if let clients know that there's a complaint process and this is what it is, if I'm capturing the information correctly. Because we can do that. We can send out a Gov delivery blast in the blink of an eye. So if that's kind of what you're wanting to get across is communicating, and I'd have to talk to Bob and Tina and Trampus about how to say, because we don't like to say things out and say, hey, you should, because should is not a regulatory word. We live in the word of may or must. Here's an option, here's an obligation, right? So we would have to talk about how we would communicate that. But if the board wants us to reiterate to licensees, to let parents and clients know about their recourse, that's certainly something I can talk to leadership about. Does that sound good?
We can certainly do that. This is Bob.
Right on. Does that kind of get to your thoughts, Jamie?
It does. I mean, I think these kids are extremely vulnerable, and if something happens and their parents don't even know what's available, it can continue to move on and happen again and again to other children. And I just think that that's one of the most important things that can be a tool to help keep these kids safe.
Great. Certainly something we can do is let them know about the complaint process. Does any other board business, anything anybody wants to see on the next agenda? Just as a side note, we just finished up with legislation, and while HLO has an awful lot of things to do, none of them directly affect this board, which is why we didn't mention anything. So I'd catch up on that. Is there anything else anybody wants us to do? We've got a couple of to-do items for the next agenda. We'll obviously, we're going to send out those standards. We're going to look at possibly communicating about the complaint process. And we're going to work on maybe an FAQ for supervision and the wet signature picture that we talked about earlier. Did I miss anything? Does anybody want to add anything? If not, I wanted to thank Mason and Jamie for joining us, and Bob, if there's nothing else, we can be adjourned.
You're going to have to ask Megan. She's in charge.
Well, I was handing it off to you so you can hand it off to Megan, because you're both in charge.
Thank you so much for having me.
Thank you, Mason. We can look forward to continue to work with everybody. Chair, if you're ready, you can adjourn the meeting if there's nothing else.
I don't have anything else. So the Behavior Analysis Regulatory Board meeting is adjourned at 11:02 a.m.
Thank you very much, everybody. Have a great, safe weekend. Stay cool.
Bye-bye.
You too.
Thanks,
Bye-bye.
y'all. Have a good weekend.
Bye.
Bye.
Thank you. Bye-bye.